So on the record on cause number DC 234202, Nava versus UCARS Management LLC. Council, make your appearances.
Jamie Sollett on behalf of intervener defendant Cameron Townley and Lizeth Nava.
Mitch Myers on behalf of the estate of Mitchell Key Gillard Jr. and Kim Gillard.
Mr. Butler.
Clark Butler on behalf of defendants Stephen Bogle and Smyrna Ready Mix Concrete LLC.
Let's proceed.
Your Honor, I represent a husband and a wife. This involves a fatality accident in which my client has brought the original suit, and there were interveners, the heirs of the decedent, Mr. Gillard, who have intervened and filed, particularly for this hearing, a negligent entrustment claim against Ms. Nava's husband, Cameron Townley. For purposes of background, Ms. Nava was disabled in a travel lane on I-35 South. Her vehicle was hit by Mr. Gillard, and a Mr. Bogle driving a Smyrna Ready Mix Concrete truck as part of a convoy. Mr. Gillard's vehicle made contact with Mr. Bogle's, and that's kind of the underlying accident. But Mr. Townley was not in the vehicle. He, according to Ms. Nava's deposition, Mr. Townley bought his wife the vehicle. They were married in 2018. They bought the vehicle sometime after they were married. It was her primary vehicle that she drove. It was in his name because they had better credit, and she testified that it was the vehicle that she used. Here, we filed an MSJ on behalf of Mr. Townley because Ms. Nava exercises joint control over the vehicle, and she testified that she did. And for those purposes, they are married and it is community property. And so he could not have entrusted that vehicle to her. And for that reason, he should be, dismissed from this suit.
Response?
Judge, they must conclusively establish the right to judgment, and what they're relying on is a community property presumption in the family code that was established to ease the division of property in suits based on suits for dissolution of marriage, of which that is not this case. It basically, just that presumption alone can be rebutted. It is not in any way conclusive. It states so in the family code. And again, I'm not even sure that really applies, because what would apply here is the title of the vehicle. And that is in the name of Mr. Townley. That is undisputed. In her testimony, she couldn't even remember when it was purchased. Again, she stated that his name is on the title. That is in the police report as well, that he is the listed owner of the vehicle. And the testimony itself also contradicts as far as the nature of property, if we want to go into the family code, because, which again, I state does not apply here. As she states that it was a gift to her, which would not make it community property. That would make it separate property. But of course, we also have evidence that it's his separate property. Because under the Certificate of Title Act, he's the owner of the vehicle. If you ask another party, be it the police, as I stated here, he's the owner, the Department of Transportation, the dealership, the holder of the note, they will state the owner of the vehicle is Mr. Townley, who can transfer title of this vehicle without Ms. Nava. He controls this vehicle. He is the owner. All we have to go on are the statements of the parties, and the case that we cited.
Are there any cases that kind of address this issue involving can a spouse negligently entrust the vehicle to another spouse? Is that something that's the courts have spoken on?
I was unable to find anything that references their presumption they rely on outside of family law cases.
Ms. Sella?
Yes, Your Honor, what we have in our motion, and I apologize, I can't see the proper screen right now. But the other thing I'd like to address, Your Honor, is that there's been no evidence to refute Ms. Nava's testimony that she exercised control over it. So while, yes, there is a title in Mr. Townsley's name, there is nothing to refute that she
But
also.
isn't the law that that's at least some evidence of ownership, the title? I've seen a number of cases that say that.
Yes, that is some evidence, but what I'm saying is there's nothing that says that she doesn't also, according to the purposes of ownership for negligent entrustment, that she didn't also own it.
But she's not on the title, right?
Correct.
All right, summary judgment is denied. And did you guys submit an order?
There should be a proposed order on file, Your Honor.
Let me take a look. If I can find it. Have you all been to mediation on this case yet?
Not yet, Your Honor. I think we are scheduled. We have more depositions coming. And then I believe we have mediation scheduled for September 12th.
That sounds right.
All right, there's a couple of summary judgments in this case. Well, there's been a lot of filings.
I can email one to the court, Your Honor, just so.
No, that's okay. Can you give me the date that this particular one was filed or order?
And unfortunately, Your Honor, since I'm kind of coming off the bench and substituting on this one, I can't give you a clear answer as to what when that was filed. I did ask for them to email me one, so I do have one I can. So I would guess it was probably Friday, not today.
I think I have it. Let me see.
Your Honor, if I may, I believe a motion for unopposed motion for late filing of a response was presented to the court on, I think, on Thursday, along with the response and order denying. So.
Okay, so this is the order denying intervener defendants Cameron Townley's motion for summary judgment. That's the correct motion, right? Or the correct order. Is that right?
That's my understanding, yes.
I mean, so the order that I'm looking at the moment is order denying intervener defendant Cameron Townley's motion for summary judgment.
Yes.
That's what you want me to sign.
Yes, Your Honor.
All right, I'll go ahead and sign that, and you have a great rest of your day, guys.
Thank you.
Thank you.
There you are.
Clark, pleasure not to argue with you.
I seen you again.
You have a good one.
You too.
All right, is there anyone here on our next hearing? I think we may be a little early. Who else do we have on the Zoom? Attorneys? None. I'll go ahead and stop this.